lecture. It is my great pleasure and privilege to introduce to you Professor Robert Post, who is this year's lecturer. Professor Post is the Alexander F. and May T. Morrison Professor of Law at my own law school, Boalt Hall, the University of California at Berkeley School of Law. He graduated summa cum laude from Harvard in 1969 and earned his J.D. at Yale, where he was note editor of the Yale Law Journal. Professor Post returned to Harvard to earn his Ph.D. in the history of American civilization. After clerking for Chief Judge David Bazelon of the U.S. Court of Appeals for the D.C. Circuit and for Justice William Brennan of the U.S. Supreme Court, Professor Post practiced with the Washington, D.C. law firm of Williams and Connolly as a litigator. He joined the Boalt Law faculty in 1983. Professor Post has held fellowships from the Guggenheim Foundation and the American Council of Learned Societies. He is a fellow of the American Academy of Arts and Sciences, and from 1992 to 1994, he was general counsel of the American Association of University Professors. Professor Post has been described as a unique figure in American First Amendment scholarship. In 1995, he published the book Constitutional Domains, a collection of his essays exploring how essential constitutional principles order social life in three distinguishable and distinctive ways. Using First Amendment doctrine and theory as a rich illustrative example, the essays explore the connections and tensions between the social orders of community, management, and democracy, as well as how the tensions between the internal logics of each of these forms of social order inform our understanding of the First Amendment. As Larry Lessig, our last week's inaugural Frye lecturer, has written, Constitutional Domains is an important book by one of America's foremost constitutional scholars. Its method is distinctive and its conclusions are rich. It should be at the center of our thought about free speech in America. In addition to Constitutional Domains, Professor Post has authored numerous influential articles on First Amendment theory and constitutional jurisprudence more generally, addressing topics ranging from censorship and human rights to anti-discrimination law. Prominent among Professor Post's current projects is his continuing work on Volume 10 of the Oliver Wendell Holmes devised History of the Supreme Court. The Oliver Wendell Holmes devised project, as many of you know, was launched in 1955 by an act of Congress, funded largely from a bequest by Justice Holmes. In the contemplation of the Congress, the devised trustees and its editor-in-chief were to commission one or more scholars of true distinction to prepare a detailed, multi-volume history of the court. The persons subsequently commissioned have indeed all been scholars of the first rank, and selection to author a volume of this work is in and of itself a prestigious recognition of scholarly attainment. Volume 10 covers the period of the Taft Court, and today in this 34th Currie Memorial Lecture, Professor Post draws on his research and thinking about the Taft Court to speak about issues of federalism faced by that court. Professor Post, we are delighted to have you with us today, and we look forward to your lecture.
It's a propitious time to be here at Duke, and I'm not just talking about basketball. It's like even in Berkeley, Professor Dean Bartlett's energy and her leadership and her vision have become palpable, and it's a pleasure to be here to see it firsthand. Thank you. This is a lecture, as Kate said, about federalism, and it represents work that I'm doing on Volume 10 of the Holmes Devise. I've been working on this for longer than I care to say. It's a volume that has a history. It was originally given to Alexander Bickle to write, and he worked on it some, and he died. And then it was given to Robert Cover, who worked on it some, and he died. And then I was asked to do it. And I tripled my life insurance and said yes. I was actually sort of disappointed to get this volume because one wants to write about the great drama of the 1930s and the confrontation with the New Deal, or to write about Lochnerism the first decade of the 20th century, and the 20s are an odd time in American jurisprudence, very spongy time. You know, you think of 20s in American culture, you think the Jazz Age, you think Fitzgerald, you think Hemingway, you think T.S. Eliot, and what's American jurisprudence in the 20s? I bet most of you couldn't name 20 cases from the 1920s. And this, you know, you think of Pierce versus Society of Sisters, or Myers versus Nebraska, or maybe you might think of Atkins, or maybe you might think of Myers versus United States, but it begins to run out pretty quickly. And the question is, of course, why is it that the Supreme Court, the court I have to write about when William Howard Taft was Chief Justice, and I bet most of you didn't know that William Howard Taft was Chief Justice, why is it that it has sort of died in our memory so completely? And it has nothing to do, let me say, with the distinction of the court. The court I'm working on is an amazing institution. It has in it Oliver Wendell Holmes, for one. It has Louis Brandeis. It has Harlan Stone. It has Taft, who was the only man to be both president and Chief Justice. It has a craftsman of the First Order, William Vandervander. It has Sutherland, who was, whatever you want to say about him, a major theorist of the right. It is a very powerful, smart court, far more distinguished than, say, our present court in terms of the qualifications and perspicuity of its members, and yet its jurisprudence has not lived. And I think, in fact, the jurisprudence didn't survive because it's a court that was caught between periods. It's a court that's conceptual apparatus comes out of what Bruce Ackerman might call the Second American Republic. It's oriented toward the protection of property, toward the division of power between federal and state governments in ways that the court had been since the 1870s. And yet it was the first court to face modernity straight on. First court to look at America in the aftermath of World War I. I mean, think of America in 1910. You have this enormous debate between progressives and conservatives, laissez-faire or regulation of the economy. Walter Lippmann caught this in the notion of drift or mastery. Should we allow the economy to drift, or should we have mastery? And these are fighting debates in 1912, 1913, and along comes World War I. And of course it's mastery. The government takes over everything, as we'll talk about in a few minutes. The debate is over. And then comes the 1920s, and what do we do with this fact? How do we assimilate the enormous change in American constitutional landscape caused by World War I? And no one has any idea, really, what to do or how to assimilate that. We don't have an idea until the confrontation of the New Deal a generation later. But this court is facing the ruins of an old world and the beginning of a new, and it doesn't know how to quite make sense of it. And as a result, its jurisprudence has kind of sunk beneath the waves of historical development. And it's particularly the case, I think, that the federalism jurisprudence of this court was derailed by World War I. World War I was a time when the United States government suddenly took charge of the nation. And then along comes Harding and normalcy, and the question for the court is, how do we understand now the relationship between the federal government and the states? And it's particularly interesting to look at the federalism jurisprudence of the Taft Court, because of course now we have a court which is reviving federalism. We have a court now which, for the first time in people's living memory, are striking down congressional statutes on the grounds of it doesn't have commerce power, or on the federalism grounds, that you see cases like Seminole or Morrison. And the understanding of the court's treatment of federalism is always put under the sign of renaissance, of reviving. Your Chief Judge Wilkinson here talks about the activism of the modern court as reviving the structural guarantees of dual sovereignty. So this image of reviving is reviving what? Reviving the federalism jurisprudence before the New Deal. Well, if you look at that federalism jurisprudence, you can look at the Taft Court, 1921 to 30, because that's the court that sets the compass points for federalism, that creates the tension which is going to play out in the New Deal. So if you're going to revive anything, you better know what you're reviving. You better look at what the Taft Court did with these questions of federalism. So it's that question that I want to sort of put on the table for you. It's always, of course, dangerous to look at the past for lessons to the present. It can be a very treacherous thing to do. But I want to stress 2 points in this lecture. The first has to do with the image of how you relate federal and state systems. The Taft Court had an image of the relationship of the federal system to the state system, which goes under the sign of dual sovereignty. The feds have their sphere of authority, the states have their sphere of authority, they're separate, they're independent, they're distinct, they don't overlap, we're going to disengage them. And as I hope to tell you in the course of the lecture today, if I have time, that led to conceptual disaster. It led to the disaster of craft, it led to doctrinal catastrophe, and yet the modern court, in cases like the Morrison case, those of you who know this case, this is the case in which they struck down the Violence Against Women Act, and in the discussion of that case, they seem to be imagining federal-state relationship on a similar image of separate and distinct spheres, the truly local, the essentially national, the family versus the market, all of these divisions, which the Taft Court, of course, has in its mind and attempts to implement in a nationally integrated economy. And so one of the things we're looking at is what happens when you attempt to do that. And the second point I want to stress is that if you look at the Taft Court, it becomes absolutely clear you cannot distinguish structure from rights. I mean, when we teach econ law, we put structure over here, what are the federal, what's the state, what's power, and we put rights someplace else, as though they were in distinct boxes. And if you look very carefully at the federalism jurisprudence of the Taft Court, you will find that there is a constant dialectical relationship between the vision that the court implements in its rights jurisprudence, its protection of property, and its structural decisions. And you can't understand one without the other. They are in constant relationship to each other. And I suspect that is also true of the modern court. I suspect, for example, that the modern court's hostility to anti-discrimination law, which you see in decisions like, well, you've seen its interpretation of Title VII, is essential and essentially connected to its structural decisions in cases like Kimmel or recently Garrett or Morrison and so forth. So a second lesson I want to draw from this historical excursus is the relationship between rights and structure and how we have to keep an eye on that, what that tells us about issues of federalism. I'm going to have 4 parts to this talk. The first part, I'm going to talk about congressional power and the way the court imagined congressional power. The second part, I'm going to talk about federal common law, the court's protection of a national market and its use of general common law to do that under diversity jurisdiction. Third part is dormant commerce clause. When is it that the state can regulate in a way that impacts on the national market? And fourth, an area which has dropped from sight, intergovernmental tax immunities, because it's a particularly clear way of understanding how the court imagines state and federal governments relating to each other. So let me turn first to the issue of congressional power and how the court imagined congressional power working. And one can't understand this topic until one appreciates the full scope and its significance of World War I. In World War I, the federal government, for example, takes over and operates all the railroads in the country. It takes over the shipping of the country. It takes over the telegraphs of the country. In World War I, the federal government sets the prices of food. It sets the prices of fuel. It regulates national labor. There's national labor policies. The living wage. The federal government guarantees a living wage for the first time. In World War I, the federal government introduces an income tax for the first time, a federal income tax on persons. There is an unimaginable, for persons at the time, increase of federal regulatory power. It was viewed as a vast extension of centralized national authority, that's the new republic, of highly centralized planning. So World War I is an enterprise that's conducted at the level of the nation, not at the level of the states. So that by November 1918, the new republic could observe that the war, and I'm quoting it now, had produced a great intensification of national spirit. We are more of a unified, self-conscious nation than ever before. Sectionalism, which not more than 2 years ago appeared to be a growing force in this country, has all but disappeared. Now, this has got to have implications for the landscape of federalism. When you have a war in which major functions are now taken over by the federal government, accomplished successfully in a way that's untouchable, you can't criticize the federal government for winning the war. What do you do after that war is done? I mean, how do you go back? How do you go back to the old ways? And the answer is with ambivalence, with tremendous ambivalence. So Woodrow Wilson, right after the war ended, Richard Hofstadter has a wonderful phrase, ended his administration in a riot of reaction. meaning he disassembled all of the wartime administrative agencies which had done these extensive forms of regulation. Along comes Harding, who was elected president. What's his theme? His theme is normalcy. He says, our supreme task is to resume our onward normal way. We must strive for normalcy to reach stability. Well, what is normalcy? It's ending the aberration of the war. And the aberration of war means many things, but one of the things it means is we have to return some balance between the federal government and the states. Even Coolidge, who is tremendously associated at the time with Jeffersonianism, with the return to local self-government and states' rights, says in his Memorial Day speech of 1925, our generation has recently lived through times still so vivid as to seem but yesterday, which have taught us deeply to appreciate the value of union in purpose and effect. But he nevertheless says our federal system, distributing powers and responsibilities between the states and the national government, means that more centralization is to be avoided. So what you see in the 20s is ambiguity, confusion, ambivalence. On the one hand, you get thoughtful people saying that the states, socially and economically, the states are antiquated political areas. They are no longer social and economic units. That's a typical statement of the time. And on the other hand, you get people stating, and this is again this typical quotation, the country had a surfeit of federal administration during the war. We want to get away from that. There is now, it is said, a revival of the doctrine of states' rights, which is returning to the vigor of former times. And of course, the standing rebuke to federal over-centralization in the 20s is prohibition. Right? Prohibition happens in the 20s, and prohibition is enacted during the war as a wartime measure and wartime self-sacrifice, and now everyone has to live with this federal police control, with federal noses in everybody's faces, and they want to get it out. Right? So prohibition is a constant spur to saying no more federal government. And what does this mean? Well, the upshot of it is put, I think, by a journal at the time called The Outlook. The Outlook used to be the spokesman for Teddy Roosevelt's unabashed nationalism in 1912, when he ran for president in 1912. But by, say, 1925, it says something like, quoting it now, there are few thinking men today who would say that, in the abstract, there should be any further centralization of power in Washington. And yet, says The Outlook, never a session of Congress passes but that some addition is made to the bureaucracy of the national capital. In other words, on the one hand, we think we should go back to the old ways. On the other hand, we can't, because we know what federal power can do. We know how effective it is. We've seen it during the war, and we continue to appeal to it. So you get this incredibly ambivalent relationship to national power. And the Taft Court, as you would expect, reflects that ambivalence. So on the one hand, the very first term that Taft is Chief Justice, he decides a case called Bailey, and it strikes down the Child Labor Tax Act. What happened was that when Congress passed the Keating-Owen Child Labor Law in 1917, which prohibited the products of child labor from moving in interstate commerce, the court in 1918, this is a pre-Taft Court decision, strikes it down 5-4 as going beyond the powers of Congress. So Congress attempts to reenact the child labor law as a wartime measure, but the war ended too quickly. So instead they passed it as a taxing power. Congress had the power to tax corporations, so they taxed any corporation that used child labor. And one of Taft's first major opinions, 8-1, Holmes joins this opinion, Brandeis joins this opinion, says you can't use the taxing power to get at things which you couldn't otherwise regulate. And there's a great paean to states' rights and how the Ark of our Covenant, says Taft in his opinion, requires that we respect the division of power between the federal government and the states. So you get this rhetorical homage to federalism. And yet if you look more closely to the actual decisions of the Taft Court throughout the day, Bailey is a dramatic exception. And for the most part, congressional power is unambiguously affirmed. The most dramatic example of this is the Transportation Act of 1920. The railroads are the most important industry in America in the 1920s. The automobile is just beginning to take off as a leading sector, but if you look at what was still the most capital was invested, the leading engine were the railroads. And the railroads were in a bad shape at the beginning of World War I because they were subject to lots of local regulation by state railroad commissions. The shippers tried to keep down prices. The railroads were undercapitalized. Service was bad. It was balkanized between many countries. So when between many states. So when World War I broke out, you couldn't run a wartime economy based on this transportation system, which was so divided by state line, and the federal government just took over the railroads. So here it is, 1920, what are we going to do with these railroads? We can't just return them back to their old state because they were a mess. And there were some who the unions wanted there to be federal ownership. They wanted them to simply own the railroads, but this being America, that wasn't really an option. And instead, we passed the Transportation Act of 1920, which was a totally different form of federal regulatory act. Instead of, as in the old days with the ICC, regulating railroads to prevent discrimination against interstate commerce, the Transportation Act, the premise of the Transportation Act was we need an efficient national transportation system. And the only way you can get it is if the railroads have high enough rates. And the only way they can get that is if the ICC regulated both intrastate and interstate rates to make sure that the railroads had a sufficiently strong income stream to capitalize and provide service. So the whole idea was to regulate railroads all the way down to the ground in their intrastate and their interstate capacities to provide a national system of transportation. Now this is a huge change in the way federal regulatory schemes are conceptualized. And Taft's first term on the court, the amazingly important case called Railroad Commission versus Chicago, Burlington, and Quincy Railroad, which challenges on federalism grounds whether the ICC can set aside intrastate railroad rates set by state railroad commissions, a very important state power because this is what the farmers pay in the local states, their local railroad rates. And the ICC is now nationalizing this. So the challenge comes, 20 state attorney generals file amicus briefs, and the Supreme Court says, this is national problem, and the federal government has full power to regulate all the way down to the ground. Basically, all the incidents of a railroad, of a national railroad system, will be now regulated by federal administrative agencies, by the ICC. And the basic premise, Taft says out, is commerce is a unit that does not regard state lines. It's one thing. Now, if you think about traditional division between state and federal, this is quite a dramatic statement, and it would be inconceivable without the intervention of World War I. And if you look at the intra-court memoranda around this case, they're remarkable for the nationalism of the vision that they show. For example, Vandervander writes a memo to Taft saying that this opinion is a vital one. It's more important than we now realize, and it's calculated to be a great factor in adjusting our present unbalanced and ill-regulated transportation system to the increasing needs of the country, and in ultimately placing it on a footing where it can serve all sections and all patrons at a minimum of cost, inconvenience, and delay. When once it comes well organized and rightly disciplined, I apprehend that the rates will become less than anyone now would venture to predict. This is a memo by someone who is one of the four horsemen, the apogee of states' rights, but he has the nationalism of the vision here is quite striking. Now, one could say that this is a result of the fact that the court had experience of national control of the railroads, and it's true. But of course, during World War I, the country and the court had experience of national control of many things besides the railroads. And this general sense of the fact that the country had a national market that required national regulatory response is pervasive throughout the Taft Court's jurisprudence and created quite a sympathetic attitude toward congressional regulation. Let me just discuss a few more cases to nail down the point. One case is called Stafford versus Wallace, and it concerned the Packers and Stockyards Act of 1921. This is regulation of the meat packing plants in Chicago. And this is upheld by the court 8-1 in an opinion by Chief Justice Taft, who explicitly brings up the analogy of the Transportation Act in 1920. So here we have, he says, Congress acting to protect, quote, the ever-flowing streams of commerce that connect one part of the country to another. And the vision that Taft puts on the table is of meat grown in Nebraska and shipped into the stockyards of Chicago and then reshipped out to the consumers of the East. And he says Congress has to have the power to regulate that stream of commerce. And that stream of commerce knows no division between intrastate and interstate. It is one stream, and Congress has the ability to protect it. Now, this notion of the stream of commerce is traditionally attributed to Oliver Wendell Holmes in a 1905 opinion, also dealing with the Packers, called Swift versus United States. And that dealt with the application of the Sherman Antitrust Act to the Packers. And the key fact that Holmes turns his opinion on is that the Packers intended to damage interstate commerce. The intent to restrain interstate commerce was what the key to federal jurisdiction was for Holmes in 1905. By the time we get to 1922 and Stafford, Taft is confronting a different problem. He's not confronting the regulation of specific actions as to which one could characterize intent. He is considering the facial validity of a law that governs. And so this is a real problem. And how does he get federal jurisdiction over the stream of commerce? Clark, who's another justice, writes to Taft, this is a real issue. He says, I really doubt the soundness of the expression that an act of Congress can supply the equivalent of intent in the conduct of parties which led to the conclusion in the Swift case. Must not the intent be found in the conduct dealt with? That binds it together so that courts will not dissect it and affirm or condemn its separate elements, but will deal with the transportation and the transaction as a comprehensive whole. The fact is, says Clark, there's something of finessing to be done in this case, and you are so much more capable of that than I am that I'm sure I can't be of any help to you, he says, writing to Taft. So what is this finessing? Taft finesses it by deferring to Congress. This is the first case where you see Taft and the court saying, we will defer to Congress on the notion of whether interstate commerce needs protection. This is a major ground shift in the way in which congressional commerce power is conceived, and Taft does it in order to provide the groundwork for Congress's ability and the court's trust of Congress's ability to perceive and protect a national market. Two more cases and then we'll leave this topic, and these two cases tell us something about how the Taft court imagines this problem. The first one is called Hill versus Wallace. It's decided on the same day as the Child Labor Tax Act, and it concerns the regulation of the grain markets. Congress passed a law regulating the trading in grain, again in Chicago, and it did it by using the taxing power, just like it did the child labor tax. And the Supreme Court of the United States strikes it down, saying, gosh, if you can tax anything you want, there will be no limit on federal power. And so they strike it down, but Taft writes the opinion, and very cleverly, he says, but of course, if this was an interstate commerce power, it would be a different story. So Congress takes the hint. Within 2 weeks, they introduce a bill to remove obstructions and burdens on interstate commerce in the grain trading markets. The act, called the Grain Futures Act, is enacted within 3 months of the Hill opinion, and it comes up, and the court affirms it in Board of Trade versus Olson. I managed to get a hold of the docket books, and Holmes votes against the constitutionality of this act. Holmes, who writes the Swift opinion, says, this can't be constitutional. Taft convinces him, and Holmes changes his vote in public. But this is a regulation of classic interstate transaction in a trading market for futures for grain. And Taft says, no, this is again the stream of commerce. People growing it in the Dakotas, shipping it to Chicago, baking it into bread, and going east. So Olson, interestingly enough, affirms the exact same regulations that the court had struck down in Hill. And the only difference was, on the one hand, Congress said it was doing it under interstate commerce, and on the other hand, Congress just did it under the taxing power. So what becomes clear here is that the court wants to give Congress the ability to regulate and protect the national market, but it has to do it in the right way. It has to do it in a way that's focused on the market. It can't do it simply by saying I can tax whatever I want. And when the court conceives this national market, it does so in a way that is strikingly analogous to the railroad cases. It imagines interstate commerce, I'm quoting it now, as a great interstate movement, a current that flows from the west to the east and from one state to another, uniting the nation. So what we get is that the railroad cases are really emblematic of a perception that is nailed down after World War I, which is the country is one country, the market is one market, and Congress can perceive and protect that. Now, there is a qualification I should introduce into this generalization, which is a little complex because it requires me to tell you something about the court's substantive due process jurisprudence. And that is that in the 1920s and before, the court distinguished between two kinds of property. There was ordinary property, about which there was a presumption of liberty. The government can only regulate that kind of property if it had a good reason. And then there was something called property affected with a public interest, what we would call a public utility, which could be, according to the court, intimately regulated by the government without any additional justification. So for example, for property affected with a public interest, the state could set prices. It could set prices for railroads, for example, or electricity. But it couldn't set prices for ordinary property. And this difference is the difference between a form of property which the court understood to be involved in systems of regulation and of so important to the public that everyone depended upon it. So the railroad was a unit. It was a systemic unit. and it was essential to the country, therefore will make it a public utility, therefore subject to governmental regulation of the intimate kind. Whereas ordinary property, the kind of property that you and I would have, or a small business owner would have, that's ordinary property, and the state could only regulate that. Remember, this is the era of Lochner. The state could only regulate that if it had a very good reason. Now, what's interesting is the cases I've just described to you, the railroad cases, the stockyard cases, the grain cases, that is all about public property affected with a public interest. That is all about the property which has already been given over to governmental regulation. Barry Cushman, a historian, a very distinguished historian of the New Deal, has noted the fact that Congress only sought to exercise its power, for the most part, over that kind of property. And that when Congress sought to exercise power over a different kind of property, the court responded in a different sort of way. That's one way of understanding the Child Labor Tax Act. It's also a way of understanding the opinion of Hammer versus Dagenhart. In Hammer, the court had struck down the Owen Keating child labor law, which I described to you earlier, which was enacted in 1917, in which Congress said you can't transport the products of child labor in interstate commerce. Now that was ordinary property, and the court was solicitous of ordinary property. It wasn't about to give over unbridled authority to Congress to regulate ordinary property, and it struck it down 5-4. Now notice, that implication is that there's some relationship between the court's philosophy of substantive due process and the kinds of power they were willing to give to Congress. One can see that contrast in a case called Brooks versus United States, which is the Taft Court decision. That's the National Motor Vehicle Theft Act. Congress made it a crime to transport stolen motor cars in interstate commerce. This is the time when motor car law takes off. It's very interesting. And the court upholds that unanimously. Now, Taft, who writes the opinion in Brooks, is a strong supporter of Dagenhart. He said the court was right to say Congress couldn't prevent the transportation of child labor products in interstate commerce. Why? Because it was merely an attempt to regulate manufacturing, ordinary manufacturing in the state of origin, and the products of child labor were harmless in and among themselves. Well, look at the Motor Vehicle Theft Act. Why did Congress pass that? Because they wanted to prevent theft in the state of origin of the car, and a stolen car is no more dangerous than any other car. It's harmless in itself. So it was exactly Hammer versus Dagenhart. But what is the major difference? The major difference is in Brooks, Congress is enacting a law to sustain ordinary property, to protect the property owner's right to their cars, whereas in Hammer they are regulating that right. So the distinction between laws protecting ordinary property and laws which are regulating ordinary property finds its expression in the structural limitations which the court is willing or not willing to put on congressional legislation. And that is not an accident. Because the distinction between federal and state power in the 1920s was conceived of as a question of, and here I'm quoting a contemporary account, but it was conceived of as a question of reconciling centralization with self-government. So what does that mean? Self-government is state government. I govern myself. How do I govern myself? In my local community, in my state. What is the federal government? That's not state. That's not self-government. That's centralization. So the images of federal regulation were of, I'm quoting now, just at random phrases you see out of the literature, bureaucratic hypertrophy, or a remote government, right? The federal government is distant, it's bureaucratic, it's them. What is the state government? The state government fulfills true ideals of liberty and democracy. The state government is local self-government. Right? The best summary of this is by Henry Wade Rogers, who was the dean of the Yale Law School, and he distinguishes, he says, the writers on political institutions have pointed out many times the advantages of local government over centralized government, and they have taught us that local self-government develops an energetic citizenship and centralization an enervated one. That under local self-government, officials exist for the benefit of the people, and that under centralization, the people exist for the benefit of officials. That under local self-government, every individual has a part to perform and a duty to discharge in public affairs, while under a centralized government, one's affairs are managed by others. Now, that's exactly the distinction between ordinary property and property affected with the public interest. Property was known as affected with the public interest because it could be managed, because it was disconnected from self-determination. And ordinary property in the 1920s was protected because, and here I'm quoting from the New Republic, on the supposition that individual liberty and self-determination could not exist without a scrupulous respect for titles to property. and a free hand for individuals in acquiring it and using it. So why do we protect property? Because property allows you to realize yourself individually, just like state government is local self-government. Why do we manage property affected with the public interest? Because that needed management to work. And so you could give property affected with the public interest to the federal government because that already is disconnected from the value of local self-government. So there are deep similarities between the court's structural jurisprudence, what it would and would not allow Congress to regulate, what in fact Congress chose and chose not to regulate, and its underlying philosophy of substantive due process. Now, we can see this more clearly if we turn from the question of congressional power to the question of federal common law. What I've argued so far is that after World War I, the court becomes really entranced with the notion of a vibrant national market that needs protection. And the court understands that market to consist in the rights of private transactions. That was the market was. And of course, the court's purest expression of those rights was its substantive due process jurisprudence. The right of liberty of contract was what it meant to be involved in the market. And when one sees that, one can see that the notion of substantive due process and the notion of the national market were always twinned. If you go back to the first of the substantive due process cases, it's Allgaier versus Louisiana. You probably read it in first-year con law, and that's the case where you get all this stuff about right to contract and carry on the common callings and stuff. But actually, that case was about a Louisiana law which forbade citizens from entering outside the state into contracts of insurance with foreign insurance companies that had not complied with Louisiana law. What that meant was, if you wrote a letter to a New York insurance company and you lived in Louisiana to insure property that you had in Missouri, Louisiana could make that a crime. And so what the Louisiana statute did is cut off access to the national insurance market. Now normally, the court protected access to the national market through the Dormant Commerce Clause, but the court had already held that insurance is not commerce. Insurance is merely a contract. And so it couldn't use the Dormant Commerce Clause to strike down this Louisiana law which prohibited access to the national market. So what did it do? It used substantive due process. And in the Allgaier case itself, it said, of course Louisiana could regulate these contracts inside the state. What they couldn't do is use that power to prevent you from entering the contract outside the state. Right? So it's not so much, that case, about liberty of contract, with the way it's normally taught and understood. It is about using substantive rights to protect access to a national market. And that's the way Allgaier is read in the 1920s. Even Holmes, for example, no friend to substantive due process, writes an opinion in 1922, striking down in Arkansas 5% tax on premiums paid by Arkansas residents to out-of-state insurance companies not authorized to do business in Arkansas. They charged you more if you went to an out-of-state company than an in-state company, and Holmes, in that case, reads Allgaier to stand for the proposition that although, quote, the state may regulate the activities of foreign corporations within the state, it cannot regulate or interfere with what they do outside. And another case, Compañía General de Tabacos de Filipinas, reads Allgaier for the proposition that the state may not compel anyone within its jurisdiction to pay tribute to it for contracts or money paid to secure the benefit of contracts made or to be performed outside the state. Right? So here you see an example of the court using substantive due process to protect the national market. The best example of the courts using the ideology of substantive due process to protect the national market, however, is the federal common law. And this takes us to the question of Erie and diversity jurisdiction. You probably all remember that before Erie versus Tompkins, when you had a case come up in diversity jurisdiction, the question is what law should a federal court use to decide? Federal courts will use at that time use state statutory law, but they decided that if it was a common law case, they decided on the basis not of state common law, but of what's called federal common law or general common law. The theory is that the common law is one thing in all the states, and the federal courts had as good access to it as any state court, so we'll use general federal common law to have access to it. And this means, since diversity jurisdiction is the site in which the national market is protected by federal courts, because of course you have foreign corporations coming in to states, that the federal courts use this jurisdiction to establish general common law as a way to create a uniform national business law, which was quite sympathetic to business, That's what the diversity jurisdiction was used for, and that's what the Swift versus Tyson line of cases did since the 1860s, when the court used this jurisdiction to protect municipal bondholders in the West. And when diversity jurisdiction was attacked, it was defended on quite explicitly national grounds. How else, said Taft, is an Eastern capitalist going to have confidence to invest the money in Arkansas unless they have access to a federal law in a federal court? Otherwise, the country will break apart. So the nationalism of this is quite explicit. And when diversity jurisdiction is attacked in Congress, it's attacked in exactly the same terms that, that congressional legislation is attacked. It's attacked as, I'm quoting now from a debate that occurs in the 1880s, as a centralization of power in the federal government and an obliteration of state lines. Only this form of nationalism happens through a court, not through legislation. See, that's what's interesting about it. And yet, if we think about the distribution of power between the feds and the states, is as important when federal power, national power, is located in a judicial system as it is when it's located in a legislative system. Now, the great famous case about federal common law during the Taft Court is called Black and White Taxi Cab Company versus Brown and Yellow Taxi Cab Company. And this was a scandalous case. This was a case in Kentucky where you had a railroad, and they have a contract with a taxi cab company that said, you have a monopoly. Only you can come to our depot and take passengers. Under Kentucky common law, contracts that were monopolizing contracts like that were contrary to public policy, and you couldn't enforce them. So even though this taxi cab company had the contract, they couldn't enforce the contract. So what did they do? They dissolved themselves as a Kentucky corporation. They moved to Tennessee. They reincorporate Tennessee. And they come in and they sue in Kentucky in diversity jurisdiction in federal court. And what law does the federal court apply? It applies federal common law. And under federal common law, these contracts are enforceable. So you can see this caused an outcry. And it was particularly caused an outcry because at the time this case was decided, the Senate Judiciary Committee had just passed on a law which would abolish federal court diversity jurisdiction and federal court general federal question jurisdiction. Both of those forms of jurisdiction, the Senate Judiciary Committee in 1928 voted a statute out to abolish. And so in the middle of that controversy comes the Black and White Taxi Cab case, and Holmes writes the classic dissent saying, there is any law is the law of a sovereign. So there is no sort of, to quote a different case, brooding omnipresence in the sky of common law. There is no general common law. Common law is always the law of a particular sovereign, and the sovereign here is the state. And so federal courts should apply state law. It's very interesting because, of course, Holmes himself had taken advantage of general federal common law to push his own theories of tort law. In fact, in tort law, you might have read a case called Goodman versus Baltimore Railroad. Do you remember that? This is a famous Holmes opinion where he says, look, if you're driving a truck and you get hit by a railroad at a crossing, you're comparatively negligent. You stop the car and you get out and you look down the tracks and you come back. It was a ridiculous rule. The court overturns it in the Cardozo opinion in about 5 years. But for Holmes, it was part of his theory of objectivism and torts. And this case was so controversial, this Goodman case, that there were statutes enacted in Congress, proposed in Congress, to say whenever a federal court decides railroad train crossing cases, they have to use local state common law. And there's a wonderful letter to Norris of the Norris-LaGuardia Act saying, you know, I'm told this fellow Holmes who rides around on a horse and buggy tells me I have to get out of my car. In any event, the interesting point about this federal common law is that when you look at the way the court decides these cases, it's deciding it with the same philosophy as the court uses in its substantive due process cases. So I'll read you a passage from the majority opinion, which almost nobody ever reads, in Black and White Taxi Cab. He says, this is opinion by Butler, care is to be observed, lest the doctrine that a contract is void against public policy be unreasonably extended. Detriment to the public interest is not to be presumed. It is to be remembered that public policy requires that competent persons shall have the utmost liberty of contracting, and that their contracts, when entered into fairly and voluntarily, shall be held sacred and shall be enforced by courts of justice. Right? That's the philosophy of Lochner. And that's what you see the court using this national jurisdiction to enforce. And if I had time, we would go through lots of other procedural cases where you see the Taft court increasing federal diversity jurisdiction by way of expanding its protection for the national market. Quite interesting cases, but I'm going to skip now to the Dormant Commerce Clause. This is an area of doctrine which remains with us, and the bottom line question in this area of doctrine is, how do you divide between the national market and the ability of a state to govern its population? How do you make that division? The overarching theme is, of course, that you don't want the national market balkanized. So there's a nationalism at the core of this. The court announces, in the Taft court, the typical opinion would say, by the Constitution, the power to regulate interstate commerce is expressly committed to Congress and therefore impliedly forbidden to the states. The purpose in this is to protect commercial intercourse from invidious restraints, to prevent interference through conflicting or hostile state laws, and to ensure uniformity in regulation. In the matter of interstate commerce, we are a single nation. We are one and the same people. Now, this notion of one and the same people had a very conservative spin in the area of the Dormant Commerce Clause, because if you strike down the state regulation, the implication is only Congress can regulate, and in many instances, Congress is not about to regulate. So what you get if you're a conservative justice is you get to strike down the regulation, and it's nothing substitutes. You get a regulatory vacuum, and the court is quite explicit about recognizing this. They said, in the silence of Congress, we need a uniformity, and then Sutherland says in a wonderful piece, says, even if it's a uniformity of governmental non-action. This is a tough one for conservative justice, to have to live with this uniformity of governmental non-action. Of course, that's what they, in a certain way, they believed in that, the governmental non-action. So what they're doing is they're liberating the national market from legislative regulation using the Dormant Commerce Clause. And the question then is, when do the states get to regulate and when not? And what's interesting about these cases is that very frequently they have this image of interstate commerce as a thing. And the question is, when does interstate commerce begin? And at that point, state regulation ends, and before it, state regulation can take charge. And you get this very sort of physical notion of, if a retailer, you have natural gas that's coming out of West Virginia, goes in a pipeline through a retailer, comes into a state, and in the state is transferred to, comes from a wholesaler into a state to a retailer, who then gives it to people. One gas, one pipeline, you might say, given the federal cases we've been looking at, one stream of commerce? No. All of a sudden, at the point at which the gas is taken from the wholesaler to the retailer, the whole jurisdictional scheme changes. The state cannot regulate the wholesaler, they can regulate the retailer. Why? Because all of a sudden, that becomes local commerce rather than interstate. Well, that's an arbitrary division, but why is the court tempted to make that arbitrary division? You see the court doing it time and time again. If you are selling tickets to steamboats, right, suddenly you can't be licensed by the state because the selling of the ticket is part of the interstate commerce. Now, that's one very important stream of cases. The other stream of cases come out of cars. And you could tell that this notion that commerce is divided that way makes no sense in cars, right? States make highways. Who travels on highways? People travel on highways that are going interstate and going interstate. They're both. And if a state couldn't regulate the highway for those trucks that are going interstate, you would have deep trouble. And the court knew that. Of course the court knew that. And so in the car cases, they say, well, a state can, if it regulate interstate carriers, they can require them to have a license. They can require them to have insurance. They can do all of these things, even though it's regulating what everyone agrees to be interstate commerce. So this image that you can break it apart easily comes across very quickly the complexity of the world. And how does the court deal with that complexity? They develop a metaphor. The metaphor is, if it directly affects interstate commerce, it's unconstitutional. If it only indirectly affects interstate commerce, it's okay. So if a state requires a trucker, an interstate trucker, to have insurance if they're going to use the state highways, that's an indirect effect on interstate commerce. Why? Because we told you so. That's why. There's a number of difficulties, of course, with this distinction. One is that by compacting everything to this on-off switch and not giving you the reasons underlying it, it doesn't give you much guidance if you're a state to figure out when you're direct and when you're indirect. The deeper point, though, that I want to stress, and if we had time, I would go into it in much more detail, but since I'm sort of nearing the end of the period, I'm just going to tell you, and that is that the notion of the distinction between direct and indirect becomes an avenue for the court to read its policy notions of what appropriate regulations of the national market are into this constitutional distinction between interstate and interstate commerce. So what seems on the one hand to be a state sphere of action, which is intrastate and local, and a national sphere of action, which is interstate, right, becomes determined by policies which are exactly the policies of the court's substantive due process jurisprudence. And I can show you case after case where a given set of regulations, which we know to be imposed by the conservative court on policy grounds, are suddenly viewed as direct regulations of commerce, whereas regulations like the licensing requirement that have equal impact in any sort of abstract sense on interstate are viewed as direct. So it's clearly full of policy considerations, and the policy considerations are clearly connected to the same substantive property protecting outlook that the court has. So once again, we see structure and we see rights, and they're integrated. You cannot tear these two things apart. So what is the sense that underlies the court's different line of cases, which tries to draw a line between what is interstate and what is intrastate? And to get at that metaphor, I want to turn to this last area of doctrine, which is intergovernmental tax immunities. And intergovernmental tax immunities is basically the notion that the federal government can't tax the instrumentalities of the state, and the state can't tax the instrumentalities of the federal government. It goes back to McCulloch versus Maryland. Remember McCulloch, where Maryland taxes the U.S. bank can't do that, right? And after the Civil War, in a case called Collector versus Day, this gets expanded into a very important doctrine. And to tell you the image behind that doctrine, I'm going to quote for you. Day brings before us an image, quote, of the general government and the states as separate and distinct sovereignties, acting separately and independently of each other within their respective spheres. Day says that each is supreme in its appropriate sphere, but that we have to separate these spheres because, quote, the great law of self-preservation, as any government whose means employed in conducting its operations, if subject to the control of another and the state government, can exist only at the mercy of that government. So if I can tax you, I can destroy you. That's the idea. So if the states can tax anything that had to do with the federal government, they can destroy the federal government. We have to keep these spheres distinct. And it's well known in the history of this doctrine that the Taft court took this doctrine to extravagant lengths, to crazy lengths. And to give you some example of that, I'll give you a case which is famous if you study this stuff, called Panhandle Oil Company versus Mississippi. And in this case, there was a general sales tax, which Mississippi has. When you sell gasoline, you have to pay a sales tax. You have a dealer in gasoline, and he's selling gasoline to the federal government. And he says, you can't charge me a sales tax because I'm selling to the federal government. And the court says, yes, that sales tax increases the cost of the federal government. Therefore, you can't have a sales tax with regard to the federal government. So the proposition that any tax that a state does that increases the cost of the federal government, that is an amazing proposition, which, of course, Oliver Wendell Holmes saw right away in his dissent. This is what he said. He said, I'm not aware that the president, the members of Congress, the judiciary, or to come nearer to the case at hand, the Coast Guard or the officials of the Veterans Hospital, because they are instrumentalities of government and cannot function naked and unfed, hitherto have been held entitled to have their bills for food and clothing cut down so far as their butchers and tailors have been taxed on their sales. And I had not supposed that the butchers and tailors could omit from their tax returns all receipts from the large class of customers to which I have referred. The question of interference with government, I repeat, is one of reasonableness and degree. And it seems to me that the interference in this case is too remote. Well, that's clearly right. There's something obsessive and strange about a case which tries to say any tax that has an effect on the other unit of government has to be set down. It reached its apex, let me say, in a case called Long versus Rockwood, which said that any income you derive from a federal patent couldn't be taxed by the state. And this was so outrageous that it was overturned unanimously 4 years later in the context of copyright. But the question for us is, what would lead the court to these really very strange decisions? And the answer is, they had an image of what the federal and state systems were. They were separate spheres, and they had to be kept apart. Now, sometimes this is called formalism. Sometimes we say the problem with the pre-New Deal court was that it's formalist. They had these rules. They didn't know why they were doing it. They were these abstract rules, and they were pursuing it in the abstract. But that's not what's going on here. This court knew what it was doing. It had a very clear perception of what it wanted to accomplish. And the problem is, what it wanted to accomplish made no sense in the context of an integrated economy like the United States. Stone saw this very clearly. He wrote to T.R. Powell in a letter. He said that the court dealt with the whole question as an infringement of sovereignty and treated the sovereignty infringed as though it were of a government wholly foreign to the taxing government. And thus, I think, left out of account the necessity of making the two governments function together as part of one system. So notice the premise of the dual sovereignty is they are separate and distinct. They're not one thing. Now the mark of one thing is balancing. The mark of one thing is we have to understand how these two things are going to work together, and we have to take all the considerations into mind to do this. Well, Stone proposed a method within 1 year of getting on the court in a case called Metcalfe of deciding to reinterpret the intergovernmental tax immunities doctrine in a way that would do that. And he basically said, what's the point? The point is we don't want to tax in a way that impairs the ability of the other government to function. That should be our test, not whether it affects the other government. That's way too hypersensitive. And he lived long enough in the 1930s to make his doctrine the doctrine of the court now. And he did the same thing in the Dormant Commerce Clause area. Because this notion of a line which separates interstate from dormant commerce, from intrastate, is exactly the same thing, translated now to the metaphor of commerce. The notion is that there are two things, they have to be kept apart, they have to be immaculately separated, and we're looking for the line. The court knew when it dealt with congressional power in the stream of commerce case that there was no such line, that commerce was an indivisible entity. And yet, its image of the way in which federal government and the state government related to each other was so powerful in it that it was led to see in this indivisible flow of natural gas from West Virginia into the state of Missouri that there was some metaphysical point at which the molecules changed from national molecules into local molecules. And Stone made a similar critique in a very famous dissent in a case called DeSanto versus Pennsylvania, saying this is not the way to think about the problem. The way to think about the problem is, why do you care about separating national and state areas? What do you want to preserve about each? And then you have to take account of everything that's relevant to that concern. And that became, in fact, more or less the basis of the modern law of Dormant Commerce Clause. And the Taft Court decisions drop away. You never read them because the court is imagining what it's trying to do in a way that makes no sense. So what follows from this excursion into a long lost and better left uninterred history? I think what's interesting about the modern court and what it is doing with its federalism is that it seems to be reviving a similar notion of separate spheres. In the case Morrison versus United States, which struck down the Violence Against Women Act, right? The court said very strongly, we have to separate the essentially local from the essentially national. What's essentially local? The family. So what's the National Marriage Act? I mean, the notion that you can separate in this country the essentially local from the essentially national, rather than to think about it as one country and balanced out in the way that Stone is talking about thinking about commerce or intergovernmental tax immunities. That image, when you try to actually tease these things apart and keep them apart, leads you into deep difficulty. And that's what an exploration of the Taft Court shows. And that's the terrain in which the modern court is walking. It's walking with eyes wide shut into this area that the Taft Court explored to its detriment, that image of it. And the second point is the Taft Court, as I hope I've shown you, developed its notion of structure by attempting to give articulation to a philosophy that was most at root in its notion of rights. And the modern court is doing the same thing. And when you do that, it behooves one to be extremely explicit about what your substantive notion of rights is and whether it can be defended on that ground rather than deferring it and making it implicit and inarticulate and yet the foundation of decisions which purport to rest on structural notions of federalism. Thank you.